As California braces for the possibility of another Trump administration, state officials are confronting the stark reality that former President Trump may have already gained the upper hand in the climate policy debate. With a focus on maintaining their climate regulations, California leaders are diligently seeking agreements with industries to preempt lawsuits and are urging the Environmental Protection Agency to expedite approvals for crucial clean air regulations ahead of the upcoming election. However, a looming concern is the potential for many of these policies to face challenges in a Supreme Court that is increasingly seen as hostile to climate regulation due to its Trump-appointed justices. Ann Carlson, a former leader at the National Highway Traffic Safety Administration under President Biden, has articulated the dual threats faced by California, one stemming from a potential Trump administration and the other from a judicial system that may not support their environmental goals. Recent Supreme Court rulings have already limited the EPA's authority to regulate critical environmental protections, and there are fears that California's stringent climate regulations could soon be in the crosshairs. California's unique authority under the Clean Air Act allows it to impose stricter tailpipe emission standards than those set by the federal government, provided it secures federal approval. In light of this, environmentalists and lawmakers are pushing for the fast-tracking of 8 waivers covering various transportation sectors, from trucks to passenger vehicles, before the election, as Trump's return to office could jeopardize these initiatives. Yet, industry leaders are preparing to contest these regulations in court, regardless of the election's outcome. If Trump wins, California may resort to legal strategies to delay any attempts to revoke its environmental waivers, echoing tactics used during his first term. Nevertheless, the uncertainty remains, especially if cases challenging these waivers reach the Supreme Court. With increasing skepticism towards the Clean Air Act's application for regulating greenhouse gases, environmental advocates are acutely aware that the legal landscape could shift dramatically, depending on judicial interpretations. Despite successful strategies in the past, the California Air Resources Board is bracing for inevitable legal challenges. Recent agreements with the trucking industry aim to postpone the implementation of clean purchasing mandates until waiver decisions are resolved, reflecting the ongoing tension between state regulations and federal challenges. The industry's readiness to launch lawsuits against the EPA suggests that the legal battles surrounding these environmental policies are far from over. In the context of legal strategies, the Supreme Court has employed doctrines such as the Major Questions Doctrine to limit agencies' ability to tackle issues of significant economic impact without explicit congressional approval. Additionally, the recent erosion of Chevron deference has enabled courts to scrutinize agency interpretations more closely, raising concerns about the future of California's environmental regulations. As state officials consider alternative approaches to navigate the legal landscape, establishing agreements with industry stakeholders has proven effective in mitigating lawsuits in the past. With the upcoming election poised to influence the future of climate policies, California is strategizing to assert its independence and implement initiatives that do not require federal waivers. The challenges posed by potential litigation and the political climate underscore the need for vigilant and proactive measures to safeguard California's environmental legacy.